Live here on Tuesday. Along with me is my business partner, Rebecca Chen. She's been associated with our law firm from 2010. She initially joined as an intern and she became a lawyer. Just like Emily Neumann was an intern in our office and became a lawyer and partner in office, Rebecca Chen is also a partner in our office. Rebecca and me are going to discuss today about the new announcement that USCIS made on automatic extension of employment authorization for 540 days. And we're going to discuss who qualifies, who doesn't qualify, how does the system work. We're going to discuss about the upgrading from EV3 to EV2 and the new policy memo, guidelines. What they said about is that there is a 180-day rule that you are not supposed to move out of the company after you file the upgrade of the EV3 to EV2 application. We're going to debate about that. We have some differences of opinion, how that will be interpreted, how that is being interpreted. But we'll discuss about it so that you have knowledge about what's going on. We're going to discuss about the I-485s that are getting transferred to the National Benefit Center. It definitely has increased the pace of the amount of cases that are being done. We are seeing some good approval notices that are coming from the USCIS. Even though the cases were been initially stuck with the Texas Service Center, we have seen some improvement. They are moving it to National Benefit Center and they are adjudicating the applications. Now, Rebecca, with regards to the announcement though, what do you see in the announcement there?
Yeah, so it is good news. USCIS announced this morning that effective tomorrow, May 4th, they will, there's a temporary final rule that extends the auto extension of 180-day EADs to 540 days.
So let me ask you some of the questions. They're saying that it's auto extension. For example, I'm on H4 plus EAD. My EAD and H4 is expiring in June 22nd, 2022. Now, is my EAD extended for 540 days?
If you file the I-765 application to renew your EAD timely, which means before, in this case, before June 22nd, then your EAD will be considered automatically extended from 540 days from June 22nd.
Only if the H4 is approved, actually, right? Yeah.
Yes.
Only the H4 is approved.
And if the H4 I-94 is
extended. That's the main thing though. So it's not blanketly applicable for all the H4 EAD people. It's only when the H4 is extended though. So it's definitely the H4 EADs cannot take advantage of it. The only time they can take advantage of it is that when they go and get their H4 stamping approved in India coming back. But there's a shortcut, Rebecca, that you did a video. Can you explain how, if in June 2022, my H4 and EAD is expiring, we filed H4 plus EAD. Now, when we filed H4 plus EAD, then how do this 540 days rule is extendable based on what you're saying? Can you explain it?
Yeah, so in that case, if the H1B and H4 are expiring at this time, June 22nd, the H1B extension will hopefully be filed pretty soon. We recommend that the H1B be filed in premium processing. And if so, if it's approved within 2 weeks, then that H1B extension approval will be valid until June 2025. Once the H1B holder has the I-797 approval notice with the end date of June 2025, they are eligible for automatic revalidation, which means if they go to Mexico or Canada, Mexico is kind of the more common destination because you don't always need a visitor visa to Canada. If you go, even if you don't have a valid H-1B visa stamp, if your trip is less than 30 days and you come back with an I-797 approval notice, that is still valid. The H-1B holder will be guaranteed to receive an I-94 when they re-enter, valid until June 2025. So that's not too different for the H-1B. They had in 2025 I-94 and they will receive in 2025 I-94 upon re-entry. But if the H-4 visa holder travels with their H-1B spouse, comes back in along with them, they should bring with them their I-797 approval notice, and this travel should take place before June 22nd. They shouldn't try this after June 22nd, but if it's before June 22nd and the H-4 visa holder has their I-797 approval notice valid until June 22nd, 2022, they will be guaranteed an I-94 at least until June 22nd, 2022. What we have observed happening is that if the couple are traveling together and if they are flying, most CBP pre-clearance at the international airports are giving the H1B and the H4 holder the same June 2025 end date if they are re-entering the US together, even if the H4 spouse does not have an I-797 approval notice with 2025 as the end date in their own name. So that has been something that people have been doing the past 6 months or so, ever since the H-4 EAD policy came out. So that hasn't changed, this kind of recommendation, but doing this, if you get the extended 2025 end date for the H4 visa holder, in addition to that 180-day auto extension beyond June 22nd, this policy announcement today will give them an additional year on top of that.
Please watch the video. We put a link out there. Rebecca and we have done a video on January 3rd of 2022. That video is entirely applicable to extend it for instead of 180 days, it's applicable for 540 days for H4. So for H4, it's not. What about if my adjustment of status EAD is expiring in July of 2022? I applied for extension. Previously, I was only allowed to work for 180 days. Am I now allowed to work for 540 days?
Yes, without any additional document or anything else. So if you already have an I-797 approval receipt notice for the pending I-765 renewal application, that likely says 180 days auto extension on it. USCIS has said that you don't need a new receipt notice that has 540 days on it. That 180-day receipt notice will be good for an automatic additional.
How do I show for the I-9 requirement, what do the employer need to do?
Just that same I-797 receipt notice for the I-765 application that was filed timely, which means before the current EAD expires. So a copy of the expired EAD card, a copy of the I-765 receipt notice, that would be all you would need for I-9 purposes to continue working.
What about the STEM extension, Rebecca? STEM extensions were allowed to work for 180 days when the STEM extension has been received by USCIS. Now, are they now allowed for 540 days based on these new rules?
It doesn't appear so. So the temporary final rule announcement links to a USCIS list of I-765 application eligibility categories that are eligible for this 540-day extension, and it does not include the categories for STEM OPT extensions at this time. So it includes EAD holders that have an EAD based on a pending adjustment of status application, H-4 EADs as long as the I-94 is valid beyond the EAD extension time, L2s, even though going forward L2 spouses will less and less need the EAD if they have the L2S endorsement on their I-94, asylees, refugees, but yeah, at this time it does not include STEM OPT.
Why do you think so this policy is, Rebecca? I mean, why? I mean, didn't they supposed to adjudicate all these 485 applications and make them faster? And they said that their goal is to approve the EADs in 3 months. What is this? Why are they extended? Do you think so? The USA is going in the right path overall, though.
I mean, it will be a temporary help. It's definitely better than the current situation where even with the 180-day auto extension, people are losing their work authorization. But it really is a temporary fix. It's just giving them longer to process an I-765 application that really should not take that long in the first place. But it doesn't inspire much confidence when they're saying that they plan to use up all the, or at least a significant number of this year's visa numbers based on the I-485 adjustment of status applications by September 30th. If they're now giving themselves a year and a half to process a simple I-765 application, that doesn't inspire that much confidence in their ability to approve as many I-45 applications as possible by September 30th. That should really be their main priority. Everyone would prefer an I-45 approval over an EAD auto extension.
Rebecca, let's move on to the topic of the EV3 to EV2 conversions. Now, of course, the State Department said that, oh, there are too many numbers available in EV3, none available in EV2, without checking with immigration lawyers like us, because if they would have checked with us, we would say, no, we're going to downgrade the application. You dummies don't move the EV3, you should have moved the EV2s. But anyway, they told us we all downgraded and file under EV3. Now they moved the EV2 dates, and now there are some people who left the jobs to join different companies. Mm-hmm. There are people who filed the interfiling from upgrading from EV3 to EV2, and there are some people who are contemplating on filing the 485J supplement as they directed with the California address. Now let's speak about what is this 180-day rule that if you once do the interfiling from EV3 to EV2, the policy guideline says that the person has to stay for 180 days. Can you explain where do they come from?
Yeah, so this comes from the USCIS policy manual, which is primarily for the officers. It's directed to the USCIS adjudicating officers. And this particular part of the policy was fairly recent. It was only added, I believe, earlier this year when they announced the kind of transfer of underlying basis guidance in the kind of push to encourage people to interfile from EV3 to EV2. And that new section of the policy manual basically states that if you are going to interfile basically from EV3 to EV2, or basically transfer any underlying basis, then the 180-day AC21 rule, where you have to wait 180 days before transferring to a new employer in order to keep the I-485 going, that the clock on that 180 days restarts. It's no longer from your original I-485 receipt date, but it is now going to be counted from the date that the J supplement was filed, requesting the transfer of the underlying basis. So you would, according to this policy, need to wait another 6 months from the time you interfile to EV2 before you can safely change to another employer.
But is that there in the law, AC21 law that was passed in 2001 or 2002?
It is not. So it's not in the actual statute. The actual AC21 rule just says 180 days from the time the I-485 is filed.
At that time, I-485J supplement didn't exist at that point of time.
Exactly, yeah. And so... Mm-hmm.
And Rebecca, let's look into scenarios where, what if the person has moved from company A to company B? Can company A has the EV2 approval and EV3 approval? By the time he moved to company B, there was no interfiling done. Now, can the company A file the 485J supplement using the EV2 of company A?
According to the policy manual, no, because there was supposed to be a continuation of the I-140 petitioner's job offer in order to transfer the underlying basis. Basically, in order to go from EV3 to EV2, there wasn't supposed to be any break in the job offer by the I-140 petitioner. And if before the interfile request takes place, you have moved from the I-140 petitioner to a different company, according to the policy manual, USCIS would probably say that job offer has been broken, and you would have to have waited 180 days.
I've noticed, Rebecca, some of the lawyers are doing, not me, some of the lawyers are doing, and have some consultations. What do you speak about it, though?
Yeah, we have been seeing some requests for evidence come in through consultations. So not for J supplements that our office has filed, but people have been trying to file the transfer of underlying basis J supplement even when they have changed employers. And some of the wording in the RFEs is a bit confusing, because on the one hand, the RFE seems to acknowledge that the change in employer has taken place, but it includes a paragraph that basically invites the I-485 applicant to transfer the underlying basis of their I-485 application from EV3 to EV2, because there are a large number of EV2 visa numbers available. So the RFE seems to be
inviting for the company B to use the company A's EV2 I-140 approval, even though underlying is EV3. We're going to keep watching this one at this point of time. It's within our own office, we have a debate whether or not we should use the EV2. We disagree sometimes. So we will keep watching and we'll inform you about what the results are coming up. And keep watching these things though. What about if the person is contemplating and moving and he just filed the EV3 to EV2 right now and he moves to the different company? And of course you told that the policy memorandum says that if within 180 days they may not consider an EV2. Do you see any problem for the underlying 485, or is it only that EV2 will not be considered?
Yeah, it should not jeopardize the underlying I-485 that was filed based on the EV3 I-140. I would say if somebody were to transfer from EV2 to EV3 and then they decide before 180 days to change employers, it seems like the worst case scenario is that USCIS just would not consider the I-485 in EV2 at that point, and it should at least continue processing and not be adjudicated until the priority date is current under EV3.
I would recommend strongly that if you contemplate of moving the jobs, though, within 180 days after you file the 485J supplement, I would strongly recommend that you contact an immigration lawyer before you make any of those decisions. I just want to let everybody know what's going on with regards to the movement of the cases from Texas Service Center and also from the Nebraska Service Center. We are seeing a lot more cases getting moved from these two service centers for the adjustment of status to National Benefit Center, and some of the cases that were moved from these service centers to National Benefit Center are getting adjudicated. At the same time, we're seeing more people that were filed in September of 2021 to right now are getting more approvals than that of the cases that were filed in October of 2020. Mostly because it's taking a longer time still for the cases to be adjudicated that were being filed in October of 2020. It's, as you know, that it was a big black hole at the time all of the applications went there. It took 4 months to get the receipt notices for those applications. They definitely are moving though, but much slower pace than what we have filed applications in September, October, November, December, and January of 2000 and December of 2021 and January of 2022. We are seeing a lot more pace in those things. We'll go to the question and answers, guys.
So Pramod is asking kind of along these same lines. He filed his I-485 initially in 2020 in EV3, filed a new I-485 in December 2021 in EV2, and is asking, is there any benefit in him interfiling his pending EV3 to EV2 at this point? Probably not really, since you already refiled an I-485 in EV2, so you basically have it I-485 in the EV2 and EV3 categories each right now. Kind of having one application in each lane is there is some benefit in that in case at some point, for example, in the next fiscal year, if the visa bulletin kind of reverses and EV3 ends up advancing faster for some reason. Also, as Rahul just mentioned, applications that we've seen filed recently at the end of 2021 have been getting processed, approved faster than ones filed back in 2020. So your December 2021 application was likely filed with the National Benefits Center. I would guess that would probably still get approved faster than your 2020 application, even if it is transferred to EV2.
Andalu Taluri from YouTube has his question, wrote the letters to the congressman, that's good. Received the yesterday I received 485J response, probably receipt notice though. Moved from EV3 to EV2. How much time it's taking after the 485J supplement is submitted though? The ones we submitted in January and February of 2022, they were not approved yet. There was only one single isolated case, and there is some problem with that, we actually did the request of interfiling a little bit before, so we don't know if it's a 485J supplement or the other action that entertained that particular application to be approved. But hundreds of cases have been filed afterwards. Not many cases have been approved. Is there anything to expedite it? Right now, there's nothing you can do. They are moving the cases to the National Benefit Center. National Benefit Center is actually moving a lot of these cases to the district offices, though, which is actually, if your case has moved to a district office, that's very good. If you're getting an RFE on the to request a 485J supplement, that is actually very good news. If you're getting an RFE in medical, that's a very good news. A lot of people are also asking questions. Hey, I live in some places, my case has been moved, 485 case has been moved to Florida. Is that something common? Is there a problem? That's a good news, because we see that the Florida USCIS offices are, maybe they don't have much work, so National Benefit Center is sending these files to these particular officers who don't have much work, and that's what they're trying to adjudicate the applications. The Florida office, if you don't live in that particular area, most probably is not going to call you for the interview at that location. If they feel that the interview need to be conducted, they will call you for interview at your district office. If not, they will just approve the cases. There is a chance they may issue an RFE, ask for 485J supplement again, and then approve the cases. So these are all good characters that are going on in the 485 applications. That if it moves to district office, it's very good. If you get an RFE, it's very good. If you move to the National Benefits Center, these are very good signs that can happen with you right now.
Ankit from YouTube is asking, is it true that an H1B filed for somebody who is currently outside of the US cannot be filed in premium processing? That is not true. Any I-129 petition currently can be filed in premium processing, so that is fine. He can request his company to file it in premium or upgrade it. Mandeep is asking about receipt notice times. He filed an I-485 April 4th but has not yet received the receipt notice. Unfortunately, that is pretty common. It can take several weeks sometimes for the initial I-485 receipt notice to arrive. One thing you can try doing before receiving the receipt notice is checking your bank details and seeing if the filing fee check has been cashed. If so, then that means that the application has been accepted and is in process, even if it takes a bit of time for the receipt notice to be mailed to you.
Ram Kumar from YouTube has this question. The H4 is expiring in October of 2022. Can I go for Dropbox appointment for extension of the H4, assuming your spouse H1B is already extended? Can you go for the stamping of the H4 before the stamping expires? That means stamping is expiring in October and going again in August. Absolutely you can. You should, especially for all those people who are listening whose EAD is expiring and you want to go for stamping in the Dropbox. That definitely is a very good option that you should choose, because if you go to Dropbox and you get the H4 extension and then you already applied for the EAD extension before the EAD expires, now you have 540 days to work on the EAD extension, which is actually very, very good news though. A lot of people ask this question to me that the appointment's not available, what do you do? Now, this is not what I am telling you to do, guys. I'm not telling it's legal or not legal. I don't know about it though. A lot of people are using some brokers. Don't call me about it though, please. I'm not in charge of it. They're using some brokers who take your passwords and then keep on refreshing it and make an appointment for you. I'm not telling anything about it. Don't call me, don't call our office, don't make an appointment with us. We are not doing it. That some people are reported to me that they're doing it. That's why they're getting better appointments though. Another question that comes out from YouTube is that once I get the 485 EAD, this question comes from Kiran Chowdhury from YouTube. Once I get the 485 EAD, if I lose the job, what will happen? I recommend that you contact a lawyer. I'm assuming that you are the main applicant of the 485 application though. There are some creative ways. You can self-employ yourself. Your wife can employ you, that's another thing. You can find another job in a similar profession with some other company. There are some creative ways to avoid the problems though. So it's better to consult a lawyer that they can give some creative ideas. Are there instances where people have self-employed and you have gone to the 485 application, yeah, it clearly says self-employment is allowed. There's a memo from USCIS that says self-employment is allowed. There are times where we have had wives sign the 485J supplement when they went for the interview. The wife was sitting next to him. Yes, I did employ this guy. Yeah, did he perform good? Hopefully she answered yes. In that particular couple of interviews, Emily and our colleagues have attended, they said yes, and then they were being given the green card. It becomes a little bit problematic because these kind of things, they will call you for the interview when you're self-employed or when your wife is employing you, and then we have to explain to them legally it's perfectly allowed. If you can avoid those things, that's better. If not, instead of having unemployment, I would rather be self-employed and then make an argument and get the green card rather than be unemployed.
Manoj from YouTube is planning to send an interfile request from EV3 to EV2 and is asking who should sign the interfile transfer request letter. So actually, starting this year, it used to be that the interfile request was just on a letter that you would send in with a copy of the receipt notice. It is now on the I-485J supplement ever since the guidance that was released earlier this year. So that would be signed. There's one page to be signed by you as the beneficiary, and then one page to be signed by the I-140 petitioner, the petitioner of the EV3 I-140, who is basically signing off that there is still this job offer for you. Sorry, of the EV2 petitioner, if you're moving from EV3 to EV2.
CS has this question, wrote letters to the congressman, thank you. Recently, company ownership has been changed to another company. Do we need to file an amendment for the ownership change? Can we file under the premium processing? It's a little bit different though. When you say ownership has changed, for example, I was the sole owner of Reddy Neumann PC. Not anymore. We are partners right now. So if that happens, though, you don't need to do anything. But if the company ceased to exist or the tax ID number has been changed from one company to another company, though, then at that point of time, it is required for you to file an amendment. Assuming that the new company is a successor of interest, you need to file an amendment for the I-140 to be active. The other thing, can you file in premium processing? We do not suggest you file the amendment in premium processing. You file in the normal processing. Once you get the receipt notice, you file in the premium processing. Why do we say that? Because it's been more than 6 months. Your labor certification has been approved. So when we file the I-140 in premium processing, they refuse it. When they refuse it, they may refuse the entire application. That's the reason we file under the normal processing. And once we get a receipt notice, we file in the premium processing. And sometimes this premium processing gets rejected. So we keep refiling. Sometimes it takes 10-15 times for the USCIS to accept our premium processing. And once they accept it, you'll get the approval though. Recently, I have to tell you that the premium processings for the labor certifications that have expired, great number of them are getting accepted in premium processing. Previously, the success rate was about 33 to 40%. Right now, the success rate is about 80 to 90%.
BVM from YouTube is asking about F1 visa denials at the consulate that he had several years ago. He's never had an H1B visa denial, but he mentioned the F1 visa denials on the I-485 form. So that's fine. The I-485 application does have a question about whether you've ever had a visa refused or denied at a consulate. So you do need to disclose that information, although I would say that it is not necessarily a trigger for an I-485 interview or denial if the reasons for the F1 denial in the past was things like insufficient documentation, which is very common, or not enough documentation of finances or ties to the home country, that sort of thing. And then eventually the F1 visa was approved. So I'd say in the I-485 form, as long as you have kind of explained it a bit, just given the details of when and what happened, that should be fine. I have included those details in I-485 applications that were not called in for an interview and that got approved without a problem. If there was something else going on with the denial, if there was any fraud or misrepresentation, that could be more serious and lead to more scrutiny by USCIS. But just an F1 denial from several years ago, if you've gotten visa applications, visas approved from the consulate since then I don't think it will be a problem.
Questions with regards to the driving license. Can I extend the driving license with the AOS EAD without getting married to the adjustment of status? That means maintaining the H4 status. Absolutely, you can. If you use the EAD just to extend the driving license, you are technically not use the EAD at all. So you are still eligible for the H4. And don't forget to watch the video, the first 7-8 minutes of our video of this one. And also there is a 10-15 minutes video me and Rebecca Chen has made on January 3rd, how to extend the H4 EAD by going to Mexico and coming back. In that video, Rebecca explained that you will extend the EAD by 180-day rule, but by today's direction, so it's not 180 days, it's 540 days you will be extending. But watch the first 7 minutes of the video and also the link that we have given there. If you watch the 10-minute video of that one, you will have a very good understanding of how to extend the H4 EAD much better.
SG Rao is asking, how long does it take for USCIS to update an RFE response in their system? It's been 2 weeks since they received it. I would say, unfortunately, that is pretty common sometimes. There is sometimes a lot of inconsistency with the USCIS case status website. Sometimes, when things are operating correctly, things are updated pretty much the same day on the case status website, but we've had a lot of situations where we don't know why, but the case status website just isn't updated at all. You may even get the approval and the case status website just doesn't get updated until then. So I wouldn't worry about it too much as long as you had tracking information that shows that the RFE response was delivered and it was delivered to the correct address. I wouldn't worry about it too much.
Aru has written letters to the congressman. What happens if I travel on advance parole outside the country and the green card is approved? Is technically advance parole, is it denied? Can I enter back because green card is not come in the mail? There are two options that you can use. If the green card comes in the mail, you can have your friend FedEx it to you and you can take the green card and come through that green card. That's allowed. But if the green card doesn't come in the mail also, good news is that you can come back on advance parole and they will not create any problem. However, when you come in the airport, they will take you a small room. Don't worry about it. We have gone through this many times. They will make you spend about 15 to 20 minutes extra there. So when they walk you to the room, don't get panicked. Don't get panicked. They'll take extra 15 minutes. You absolutely will not have any problem. What will happen in case where the people don't have an advance parole, they have a H1B and H4 and they get the green card. We told the people travel on H1B and H4. Absolutely no problem. When they came to the airport though, they took them to the small room and made them wait for 15 minutes and then they said you can go in. So we had no problem. That's one thing that's been there for a long period of time. From about 15 to 20 years it's been there. We had no problem experiencing where people get the green card approval when they are outside the country.
Manoj received an interview notice for his I-485 application to the field office and is asking, does he still need he was planning to interfile, it sounds like from EV3 to EV2, but has not yet, and is asking if he still needs to. I would say you don't need to. If your priority date is current in the EV3 category, if you're being called in for an interview to the field office, that is usually kind of the last step of the process. If everything goes well with the interview at the field office, they'll usually let you know at the end of the interview that your I-485 is being approved, and you would usually receive the permanent resident card in the mail within a couple of weeks of the interview. So I would say there's no need to interfile.
What if the priority date is backlogged in EV3 and now EV2 is correct?
Yeah,
I'll tell you some of the experience that I get recently. So these people went with the 485J application with them though. So the officer took the application. The officer didn't know how to generate the 485J receipt notice though.
Okay.
So he took time. So what I'm telling people is, hey, do one thing. Even if you get it, if your priority date in EB2 has moved advanced though, you're working for that company though, find the 485J supplement in the California address which they have given.
Okay.
And at the same time, take one copy with you, freshly dated, to the field officer, because there are some field officers who are experienced and smart field officers. They're taking, and hey, you have an EB2 approval. Let me change the EB2, and they've approved the 485 also. So I would like to do both steps if the EB2 is advanced.
Yeah.
There are some questions coming on with regards to prediction of the EV3 and EV2 movements. Rebecca, you are you are the bad one. It's not.
Oh yeah, I mean, we always hate to guess because we never are correct, it seems. I mean, so this is just my personal opinion. I hope USCIS is going to use as many of the visa numbers for this fiscal year as possible.
If they use as many numbers as possible, practically all the people who are in the pipeline should have been approved, because when we looked into the first quarter of the 2022, which ended in December 31st of 2021, 245,000 applications were being pending. So that means that all the people will be approved. So practically the priority date for all the people who filed until January of 2015 will be done, and still there will be some room left for this year.
Right.
And then next year, we have approximately anywhere between 50,000 to 100,000 that are coming next year for the excess green cards, which have been not used in this fiscal year. So that leads to...
Yeah, so that depends on USCIS, like how much we think USCIS will actually execute on approving that many applications. I unfortunately am not optimistic that they will approve that many applications by September 30th of this year, just based on the statistics they released from the last quarter. So if they don't use up all the visa numbers that they have for this year, they're going to have an excess of EV2 applications, I would think, because they've been moving the EV2 dates so aggressively, which means come the next fiscal year, starting October, I don't see EV2 moving any farther, if that's the case, if they don't use up all the EV2 numbers that they are aiming to this year.
But here, Rebecca, what we noticed is that with all the people, our audiences writing letters, we're drafting the letters. We have seen the response of the 39 congressmen writing letters to the USCIS. And now we see the USCIS extending the H-4 EADs for 540 days. There are also Twitter notices that have been issued by USCIS that they're focusing more on the employment-based. Their target is to bring down the adjudication down by 6 months. We noticed a little bit more extra green cards approved in the second quarter of the 2022. We may see more continuation in the third quarter and fourth quarter, and I see that our people are going to write letters to the congressmen. If that happens though, definitely the dates have to move. Next week we are going to give you a draft of the letter, which is going to be a little bit different, because there are a lot of people asking, what can we do to do it? So this draft letter that I'm preparing right now would be that, hey, if you are not giving the green cards, make the dates current. There are 290,000 green cards available there. If you are not giving the green cards though, move the dates. Now, there are two departments here that we want to explain to you. One is the State Department, which moves the dates of the visa numbers. One is the USCIS. Now we have the USCIS sleeping, not working. We're waking them up, they're not waking them properly though. So what we should now focus on, which we are doing, we're writing letters to the congressmen, we're writing letters, so we have 39 congressmen responded to your letters that you're writing, which they combinedly wrote a letter. This is a congresswoman from Atlanta. That's very good that she did it. Now we want to focus on the State Department. Hey, your duty is to use the visa numbers, the green card numbers. So if the USCIS is not using the visa numbers, make the dates current. If the numbers are there, you make the dates current. We're going to draft that letter and we'll put it out to you next week though. So our advocacy is right now, instead of you telling us when the dates are going to be, we want to keep that burden on you, what efforts that you are doing to have the dates moved. We have given the letters, you ask us what more. So people have asked us what more, now we are going to draft a different letter. Writing to many congressmen that doesn't belong to your jurisdiction, they don't care much about it. The people were asking that question. Now we are going to create different letters from now onwards. We are going to focus on the State Department, use the 290,000 green cards, or make all the priority dates current. Now, can that happen? Did this happen before? Yes, in June and July of 2007. The priority dates were all moved current. The State Department requested the USCIS adjudicate the application. We know how the USCIS is. They didn't say they were sleeping. They were sleeping in April. They were sleeping in May. They were partly sleeping in June, and all of a sudden in June, they said USCIS, the State Department said that we have to use 140,000 green cards. They made all the dates current, and guess what? Now the USCIS says, no, don't do that. And July, the State Department, first itself, they took it back. But because of the Congressman Joey Lufgren, we had all the people who were in present, whose labor in I-140 was being approved at that point of time, filed the 485 application. Even if the labor was approved, because I-140 was allowed, we filed the parallel I-140 and 485 application the entire of July, and because they blocked the dates, they allowed us extra 16 days until August of 2016, August 16th of 2007, they allowed us to file it. Let's try to advocate that starting from next week, because we know that USCIS is going to waste the dates. Instead of you asking us when the priority dates are going to move, we're going to move that burden. You've been doing very good job. I see so many people writing letters. I have my very, very many thanks. You're taking the things in hand. We will draft the letter. We'll put it out next week in the video link that we're going to do it next week. So we will move the burden of predicting the priority date depends on how many letters you write, how many have your friends write those things. Take it to the community, these letters, not just writing yourself though. I mean, you go to these cultural organizations, I don't see immigration stuff there. And I argued with these cultural organizations, why don't you do some efforts for these things? Okay, Rahul, what do you do? Okay, now put a seminar for the immigration. Well, they put a seminar for there. Me and Rebecca, how many people showed up in the seminar? You went to the NATA Association, Telugu Cultural Association. How many people showed up there? 2, 3 people?
Maybe 10 at most.
10 most, and out of how many people were there though? 10,000 people were there in this NATA convention. I went to Thana convention. I went to this cultural convention. Nobody shows up there. No interest is there. We need to have the social awareness that if we don't get the green card, guys, you are going to be waiting here for a long period of time. Let me tell you one thing. For the final action date to move from May 1st, 2010, one day to move from May 1st, 2010, in 2012, it took 9 years for it to move. It didn't move. We have this occasion of this extra 150,000 green cards that we get it. Last year we got it. Guess what? They wasted 60,000 of the 90,000. We have to make sure these things are not wasted. The burden is on you. Don't ask the priority date to us. Keep asking that to the congressman. They are the one who is going to respond to you. They are the one who, because they are the one who can make the USCIS work. We tried taking it to court. It didn't work out. Believe us, it does not work out in the court because they say that the courts don't have jurisdiction to take the adjustment of status adjudication application. So it's your burden. You have to solve this problem for us.
Amit from Facebook is asking, is an H1B amendment needed as a result of his recent promotion at his employer? It really depends on how significant the promotion is. USCIS has just used the term, if there's a material change in the terms of your employment, then an amendment should be filed. If the promotion is such that it changes your level of responsibility such that your job description that was in the most recently approved H1B application is no longer really applicable. And if your salary has increased such that I would say it goes up one wage level according to the FLC prevailing wage kind of structure, that is usually kind of a good indication that an H1B amendment would be needed.
Rebecca, I need your attention on this Arun Prashant question though. He wrote a letter to the congressman, that's very good. He interfiled from EV3 to EV2. Within 180 days, he changed the company. In the I-485J supplement of the new company, what should he do? I am thinking this way, correct me though.
Okay.
I'm thinking this is a debate. I am thinking that he should not even file a 485J supplement with company B.
Yeah. Mm-hmm.
In that way, what I'm thinking about is that here's my thing. Arun, if you interfile, if you file a 485J supplement with company B, you are actually pointing out that you changed the company within 180 days after you file from EV3 to EV2. Mm-hmm. Why point out to them? Just keep your mouth and get the green card. What do you think of that?
Yeah, I mean, filing the J supplement as a result of job portability is not really a hard and fast requirement. There are some companies out there that their policy is that they actually won't file the J supplement for a job change, even if it has been 180 days since the I-45 is filed. They, some companies just don't file the J supplement until there is an RFE or the I-45 applicant is scheduled for an interview. Then they say they'll provide the J supplement at that point, and there hasn't been any problem with operating according to that so far. So since there isn't really a hard and fast requirement that you file the J supplement at the time you're changing employers, that could be an option of just not filing the J supplement right away and just seeing what happens.
Yeah, and I mean, could they, if you point out, you're actually pointing out to them that you changed the job. Only if there is an RFE or if they've been called for an interview, I would definitely take the 485J supplement.
Yeah, definitely.
At that point of time, I would recommend you to consult a lawyer privately to see what are the odds. Because at this point of time, we have noticed that some of the companies are using the EV2 though. We particularly are not recommending at this point of time, but as things will develop, then we can, we can see how the things are. And we don't want you to be the scapegoat. We don't want Reddy Neumann video audiences to be the scapegoat. Let somebody else be there, and we will tell the results here because we do consultations. We get feedbacks from you guys, and we will tell you what to do. At this point of time, I recommend don't do 485J supplement. Rebecca also agrees with me on that. Kalyan is saying that he wants to write many letters to the congressman. I don't want you to write many letters to the congressman, though. I want different people writing the letters to the congressman. That would be in the best interest. So if you keep on writing, they will not honor it. That is not good. On the same topic, if you keep on writing, it's not good. Have your friends write the letter. That will be much better, though. I know your friends, how they are, where they meet, you socialize, take a computer with you there. Hey, why don't you write a congressman? I'm going to give you all the things and help you out, and then let them fill it out, and then let them submit the document. That's going to be much better rather than you writing the letters to multiple people. You keep writing, but not writing to multiple times for the same thing.
There's a question of whether you can travel to India while an H1B and H4 extension are pending. Yes, that's fine. So if you have a change of status application pending and you depart the U.S. while it's pending, that does result in abandonment of a change of status application. But for an extension of status application, it will not be considered abandoned if you travel internationally while it's pending. The main thing that you have to look out for is if you are coming back into the U.S. before the extension application is approved, you'll be issued a new I-94 at re-entry, which you are always issued a new I-94 after each entry into the U.S. that has a number that doesn't match the I-94 number that you filled out in the I-129 and I-539 forms that are pending, which means the approval notices, when they do come in, will have a different I-94 number on the cards, which results in an I-94 mismatch. It's not really a problem for your status. You will still be considered invalid H1B or H4 status. The main point that an I-94 mismatch is a problem is if you're renewing a driver's license. Sometimes that mismatch in the government's SAVE system, they're not able to verify for driver's license purposes, or with the Social Security Administration, sometimes that can cause kind of a discrepancy. You can pretty much fix it by just traveling outside the US again, like a quick trip to Mexico or Canada, for example, and coming back in. That will basically clear the slate. You'll have a new I-94 number going forward after that.
Question with regards to, can we write letters for the DOL to expedite the processing of the POM and also for the perm and also for the prevailing wage. That's a good point though. I would definitely write a letter to the Joey Lofgren. She's the one who is the Judiciary Committee Chairman for the House. Her attention need to be paid on this one too, because you're right. It's taking a long time to get the prevailing wage now, and also to get the perm process. What used to take about weeks are taking months. So the total processing time from the scratch to file and get the labor certification approval, which used to be 3 to 5 months, now stands anywhere between 6 months to almost 18 months, depending on the company policies. So definitely, thank you for bringing attention. We'll try to draft that one as soon as possible.
Mohammed from YouTube is, thankfully he got his I-485 approved recently, but his wife's is still pending, and asking is there anything that can be done to expedite it. Unfortunately, this is somewhat common. We have noticed several cases of families, even when their I-485s are all filed together, sometimes the parents get approved, but the child does not for several months, sometimes 6 to 8 months. Or one spouse gets approved and the other one doesn't, again for a number of months. So far from our observation, there hasn't been any problem with the family member's application that is taking longer to be approved. It may just be at the service center for whatever reason the cases were split up between different officers that are working at different paces. At most, if it is outside the normal processing time, you can put in an inquiry, but that's about all you can do. I would say if it's only been a month at this point, it's not really anything to worry about. We have noticed the same thing happening in other cases that ended up fine, but it could be a few months.
Drew wrote a letter to the congressman. That's very good. He was unemployed for a period of March 2017 to January of 2019 due to visa denial. He came back on B2 visa. I'm assuming that you're unemployed while you are in India. If that is the case, though, I don't see that it will impact your adjustment of status, though. You're in India, you're unemployed for a period from 2017 to 2019, absolutely not a problem in you getting the 485 application approved.
Kumar is asking if medical exams can be submitted along with the transfer of underlying basis request. It doesn't hurt to try, although I am not that confident that the medical exams would eventually be matched up to your I-485 file. Part of that is because the interfile requests, the J supplements the instructions now are to mail those to the Western Forum Center, which is in California, and your I-485 file is likely at the National Benefits Center or Texas or Nebraska, where it will eventually be transferred to the National Benefits Center. So I don't know if USCIS is kind of on top of it enough to mail your medical exams from California to the National Benefits Center. So it doesn't necessarily hurt to try, but I wouldn't be surprised if you still end up getting an RFE later asking for the medical exams.
Harish has his EAD approval filed with previous H1B, but concurrently filed along with the H1B though. But it has an expiration date of the current. He filed with the previous company, but now he moved to a different company, but he got the EAD with the new company's expiration date. That is normal though, that they do it, I would say about 20% of the time. You can use it, absolutely no problem with it. That's very good. The officer is very smart, very nice. You should respect that thing. Nina has this question. She filed a 485 in May of 2021 under EB1C in Nebraska. When can I expect my GC? First thing I don't know is, did you file the 485 application after the I-140 is approved? Is the I-140 still pending? If the I-140 is still pending, they will not approve your 485 until the EB1C I-140 is approved. If your I-140 is already approved, the time process may take anywhere between 2 months to 2 years. I repeat again, 2 months to 2 years.
Doppel has a party date that is in 2014, and that was with a prior employer. His current employer has the perm under process right now, but as As we know, perms are taking a very long time, at least a year, probably from start to end at this point, and is asking, is there any way he can file an I-485 on his own if employer A is not supportive and employer B's perm takes a long time. So you can't file an I-485 on your own because you do need the J supplement that confirms a job offer in support of the I-485. But there are a couple of I-140, there are only a couple of I-140 categories that you can self-petition. So one of them is the EV1A category for aliens of extraordinary ability. That is a pretty high standard. Another self-petition option for the I-140 is the national interest waiver, which is in the EV2 category. That also has some particular requirements about the work that you're doing. It basically, you have to show that it's in the national interest, that it has substantial merit and national importance, that you are well positioned to carry out that work, and that overall it's worth it to grant you the waiver of the perm process, because the work that you're doing is, meeting an urgent need in the US somehow. The good news is the NIW used to take about the same amount of time as the perm application, 12 to 16 months, because there was no premium processing. This year, by September 30th, we do know that premium processing will become available for the first time for NIW I-140 applications. And so if you feel like your work is arguably, in the national interest, or a good argument or case can be made for that, the NIW may be an option to consider, because it would allow you to file the I-140 without the need to wait for a perm application to be processed. With premium processing, even though premium processing is not going to be the 15-day turnaround that we have been familiar with, it sounds like it will be closer to 45 days, and it sounds like they'll phase it in. At first, it will probably only be upgrades that they'll be accepting for pending NIWs, but just the fact that premium processing is becoming available for NIWs, will help a lot of people potentially who have a good case who may not have wanted to do that before.
Shilpi Kapoor and Prabhakar have questions with regards to the interfile, refile, and explain to them. Interfile is you are trying to tell the USCIS your application is pending under 485 and EV3, and you are actually telling them to move to EV2. That's the common word. I mean, interfile can be for medicals, for a lot of things, but in general, when we use interfile, the existing application which is under EV3, you're moving it to EV2. That is called interfiling. Refiling means you are from the scratch, filing 485, I-140, 485J supplement, EAD and advanced parole. That's called refiling. In this case, you will have journeys going in EB3 and EB2 at the same time. You're not going to be in conflict. You have both the applications. We can do refiling application also. Shilpi has this question with regards to, we already filed 485J supplement at the time when we filed a downgrade application in October of 2020. Now, when we want to refile, do you still need to file a 485J supplement? Absolutely, you need to. I don't know why your lawyer has filed a 485J supplement. When you downgrade it, it's technically not needed. When you file an I-140 and 485, you don't need to file a 485J. But when you're filing 485 standalone, that means that not filing with the I-140, you need the 485J supplement to be signed by your employer when you're refiling the 485 application in EB2. You need that 485J supplement. Anything else, Rebecca?
No.
Thank you very much for tuning in. Don't forget that if you want to know more about the H-4 EAD extension for 540 days by going to Mexico, please watch the link that we have provided. It's about 7 or 8 minutes video. We made it privately only for that, even though in that Rebecca explained that you are extending the EAD for 180 days, but as of today though, that 180 days is now 540 days. That's the only difference of what we explained in January to right now. Thank you very much for tuning in, and don't forget writing letters to the congressman, and we're going to keep on drafting the letters. Please keep on writing those letters to the congressman.